Namaskara. Good evening, and thanks to the Citizens Council of Mangaluru for giving me an opportunity to engage with the audience. Coming to the topic, one of the reasons I've been speaking, writing on the subject extensively is thanks to my own personal experience of trying to project and present certain causes before constitutional fora such as the Supreme Court on subjects and institutions which are close to my heart. So, most people don't know as to what I do in terms of practice. Let me just say that so that you know why this transition has happened. I began as an engineer turned lawyer, and my primary area of practice is actually intellectual property law and competition law. Even if I say so myself, I have some degree of expertise over the last 15 years. I've been the advisor to multiple governments on implementation of IP policies. I've also represented Bharat in trade negotiations with the United States. I've done all of that. So why did I make the jump to Constitution at all in the first place? So when I joined law school, Constitution was the actual goal. But you see, Constitution doesn't pay bills. It's a very poor area of practice. It's not exactly a place thriving with a lot of money. And activism had no interest. I come from a low middle class family. I was very interested in settling my student loans and quickly climbing the social ladder. That was my very clear incentive. So I said, let me spend some time pursuing Lakshmi in the hope that I get to pursue Saraswati after that. And the idea was that I split, let's say, my practice areas in such a way that my money comes from the Delhi High Court and my passion is vetted and satisfied in the Supreme Court on the constitutional front. That's how I have largely divided it. So a lot of times what happens is, as a consequence of all these social media engagements or public engagements, people somehow get the distinct impression that I'm going around asking people to contribute funds to my cause. I don't need money from anyone. I have no interest in soliciting funds whatsoever. You want to contribute to your local Goshala, to your Vedapata for orphanages here, to schools here. Those have been Hindu priorities traditionally, and those should continue to be Hindu priorities for eternity. As far as my own transition is concerned, I'll blend it with the topic so you know why this has been so personal for me. 2016, that is from 2009 to 2016, I was part of a law firm. I rose to become the youngest associate partner in March 2015, by which time I developed a fair reputation as someone who could argue in court without the need for a senior. By which time my opposing counsels had said, if you were not part of a firm, we'd start engaging you for arguments. So by 2016 is when I decided to quit and go independent. Now, as long as you're part of another outfit, it's very difficult for you to take positions because the organization will pay the price for your positions. And particularly if they happen to be politically incorrect positions and you're fairly vocal about it, they may or may not agree. But without blaming them for anything, the fact of the matter is I decided to prove myself exclusively on the anvils of professional commitments for the first 7 years. People should know me for my professional competence before they know me for my opinions, was my approach to it. Because every Tom, Dick and Harry can have an opinion, so what? Why should people hear you? Why should people pay attention to what you're saying? They will listen to you provided you have done something, you have something to show for. And therefore the strategy, very clear strategy, at least a calculated one, was establish yourself and then you start talking on the subject. So for close to 7 years, I spent my time keeping my mouth shut, keeping my head down, proving myself exclusively as a competent commercial litigator in the Delhi High Court. 2016 June is when I went independent as an independent arguing counsel, which is in the mold of a barrister, wherein you don't interact with the client. Your sole job is to argue in court. You don't file, you don't draft, you just argue. So your clients are other lawyers who want you to argue, and the actual client is the client of that lawyer. So the client is in a relationship with the solicitor, who is the one who prepares the matter. The solicitor engages the barrister to argue in court. So I happen to be in the arguing mold. So that's the practice model that I jumped to, because by then I'd already established a reputation as someone who could fairly argue in court. Around that time, the Sabrimala case was raging before a 3-judge bench. And the three-judge bench was asking itself whether this matter is serious enough for it to be referred to a five-judge bench. And therefore, arguments were going on, I think, between October 2016 and February 2017 before the three-judge bench. There is one organization called People for Dharma, which was looking for lawyers who could take up their cause pro bono. Now, they didn't have access to me, I didn't have access to them. Neither of us knew of the other's existence. Someone on social media, later that person met me and revealed his identity, put out a message to them, a public tweet in fact, that if you're looking for someone who will fight this cause passionately, regardless of any commercial incentive, go to this guy because he's serious about these things. Now, I don't know how that person had read this about me from a distance, but that's how they said it. That's how the opportunity landed on my table. And when the opportunity landed on my table, I realized, with growing awareness and concern, that Bharat had achieved a certain unfortunate stage where all the institutions that inform its identity and civilization will now have to prove their worth before constitutional courts as to how their practices are constitutional. Religious practices and traditions that have survived and that have existed for thousands of years will now be tested on the anvils of the Constitution in front of an Anglophone audience. And traditional practices will now have to be conveyed and packaged in English for them to understand whether it is constitutional or not. Now remember, all these people, just like us, at least most of us, are people who have gone through an English education system, with or without any traditional exposure to our customs and traditions. Or even if there is exposure, there is a decent chance that they look down upon those traditions. So this is not a primary audience of children in schools, it's not a secondary audience of people in colleges, it's a tertiary audience with a lived experience of constantly having looked down upon their culture for 30 years or 40 years. And you're trying to convince them in a span of a week or so that this practice is not misogynistic, that this practice is perfectly valid. Ask yourself a simple question. Somebody brings their life experience to their jobs, and you're hoping to argue against their life experience and their worldview in a span of a few hours, trying to convince them as to why this practice must continue. Genuinely speaking, I didn't think we had any hopes of success. No hopes of success. You can't even convince children today of your customs. How can you hope to convince adults with set egos and set patterns of thinking who occupy those positions which obviously give them a certain degree of importance? There is no incentive for them to be convinced otherwise, to be persuaded otherwise. But why was the representation still necessary? The representation was necessary because if you don't vocally express your point of view, it is as good as that point of view not existing. People will therefore say, there is no alternative point of view. There is no alternative opinion. So sometimes, even if it happens to be a losing battle at the outset, at least in round one, your job is to continue hitting and kicking the door to try and pry that door open for your point of view. So knowing fully well that the odds were stacked against us, and when I mean we, it's a huge team of, let's say, a variety of lawyers. Perhaps I was the youngest to argue in that particular matter. Everyone put their best foot forward. If you had legends like Mr. Satish Parasaran, including Dr. Singhvi was arguing from this side, for God's sakes. Dr. Singhvi argued for the Travancore Devaswam board, defending the tradition on behalf of the temple in defense of the practice. A host of voices, some of the most stellar voices produced by the Indian legal fraternity, did argue from this side and still managed to come out only with a 4-1 verdict, one opinion in your favor, 4 against you. And the one person to deliver a verdict in your favor happened to be a lady in the cause which is supposed to be about women. The dissenting opinion in favor of the tradition came from a lady. And the men were saviors of women in that cause. This is unfortunately how contemporary feminism works, where men become more feminist than women themselves. And in the process, what happened was, there was a moment of churn created. Allow me to say this, everything that has happened since 2018, especially since the birth of the Sabarimala movement, has only led to a rising Hindu consciousness. Before 2018, not many people had heard the words Naishtika Brahmacharya. People in the north of Vindhyas, several parts of that country had no knowledge of this particular temple, despite Russians, Argentinians, and Brazilians coming to this temple with proper Diksha. Any number of videos put out by foreigners basically saying, we understand this, why can't you Hindus and Indians understand it? That was the extent of the problem. But sometimes I think these challenges are moments of learning and moments of churn, because they pry open the conversation from a confined box, and the entire Pandora's box is opened. Gender, jati, temple, everything comes out. And then people start thinking, okay, what do we actually know about this particular subject for us to have such strong opinions on? People started revisiting. From there, in 2018, when the first negative verdict came out, so many people who had written off Keralites and Malayalis as communists who were irredeemable and incorrigible, the women of Kerala took out processions in defense of the temple, thereby establishing that political choices and religious beliefs need not necessarily coincide. They could be different. And that possibility was out for people to see. So the educated women of the most literate state of the country came out on the streets protesting against a verdict which was apparently meant to liberate women in defense of a practice that was apparently misogynistic. Look at the irony of it. And they said, we know this practice better than you think we do. You don't need to come and save us. We can defend ourselves. There are better things for you to defend us against, not this. If at all you would really wish to intervene and protect us, there are other serious issues. This is luxury litigation. People who are utterly jobless or whose only job is to take pot shots at Hindu institutions are the ones who are behind it, and who constantly think that Hindu institutions must be in a perpetual mode of reform, and everything that they know and practice for the last 1,000 years must be junked and discarded. That seems to be the motive behind it. So it was a moment of learning, because it opened my eyes to how little I knew about an institution of which I thought I knew some. What is the meaning of this practice? How is it supposed to be observed? All the myths associated with the Sabrimala Diksha I had to unlearn. And I was put in touch with a brilliant set of people who were vastly more qualified than I am, and I was, or I will be ever, on the subject of dharma, who decided to download all their knowledge upon me, giving me the opportunity to present this before a court of law. Perhaps what I'm trying to do is to say that it was not a solo act. I just happened to be a glorified articulator and messenger of their opinions and their points of view before the highest forum of the land. And the credit must go to all those people who were behind the scenes. I also walked away with the glory partly because of social media representation, and the fact of the matter is a lot of Ayyappa Diksha, bhaktas, withstood lathi blows on the ground. I didn't have to face a single lathi blow. Right? 2, my star argument of the deity's rights came from a boy younger than I and a non-lawyer. His name is Tarun Daga. He was part of the team. He basically said, if women have rights, doesn't the deity have rights? That was the seed of the argument. And I then thought about it. So the strength of a lawyer need not be that he is the origin of an idea. He must just be open to ideas, and then he must know how to build an argument out of it and to develop that argument further. That's what happened. From there, I went to the next experience, which was the Padmanabha Swami temple case, where I happened to represent the chief tantri of the temple. And then I realized, what kind of a relationship did princely states of Bharat have with their deities? Mysore, Chamundeshwari; Jagannath, therefore the Gajapati of Odisha; Mewad, Eklingji; then Cochin, I think Purnatraisha; So every princely state seems to have its own deity, and every princely family, when it negotiated its accession with the Indian state, primarily was saying, take everything else away, but leave our rights with respect to our deities intact. Because this is our hereditary institution. If you break this relationship, there will be real consequences for us. The fear of karmic consequences was very, very real for them. And so if you go through the negotiations, I think the right-hand man of Vallabhai Patel, who wrote a book on the integration of states and who released the white paper on how integration must happen, captures it brilliantly as to how these parties negotiated with the Indian state. And then I said, okay, if 90% of the princely states were Hindu princely states, and the basis of the partition was a division between Hindu princely states and Muslim princely states, how did Hindu princely states come together to come out with a non-Hindu Bharat? How is that possible? So each of the parts have very clear religious allegiance. But apparently the unit that they form is a secular unit which has no religious identity at all. Is this what they negotiated for? How does this even work? That explains the absence of the word secularism partly in the original constitution. Because they were all participants and stakeholders to how the constitution will be framed, because it would have a bearing on their surviving rights after the accession, including the religious rights. How do you call this a secular constitution if it has a specific provision for protection of the cow? If it has a specific article, Article 295A, under which the Union of India from the Consolidated Fund of India continues to pay an annual rent to the Padmanabha Swami temple for the lands that it has taken from the temple. So temple payment is made out from an apparently secular constitution. How do you explain this? Which is why I believe it's important for us to understand the entry of secularism into the Indian constitution very, very clearly. For all practical purposes, it was pushed and forced into the draft, or rather into the body of the document, only during the emergency. So those who wish to bat for the constitution and its integrity and whatnot have a lot to answer for, because this concept and this principle was inserted in the constitution during the most unconstitutional period of Bharat, when for all practical purposes all checks and balances were in a state of animated suspension. So how do you then constantly bat for secularism? That is a question of fact, that is a question of history that needs a very clear answer.